I can't say that I am surprised about this ruling in Texas. Texas Supreme Court rules against women who allege state's abortion ban put their health at risk. The Texas Supreme Court said a medical exemption in the state's abortion ban applies only when a person is at risk of death or serious physical impairment, ruling Friday against women who sued the state with claims that the ban had put their health at risk. The state's highest court, which is made up entirely of Republicans, reversed a lower court's order that broadened the exception to circumstances in which a pregnancy is unsafe for the pregnant person, or when there is a fetal condition making it unlikely the fetus will survive. Because the trial court's order opens the door to permits abortion to address any pregnancy risk, it is not a faithful interpretation of the law, the state Supreme Court said. The ruling came in a lawsuit brought by several Texas women who suffered serious health complications in their desired pregnancies. They alleged the state's strict abortion laws put their lives and health in danger when they were forced to wait until their health seriously deteriorated before receiving the procedure, or were denied abortion altogether until they traveled out of state. The Texas Supreme Court said the challengers did not prove the ban with its narrow medical emergency exemption violated the state constitution. When the Supreme Court overturned federal abortion rights in June 2022, a Texas trigger law took effect, essentially blocking all abortions in the state other than those performed when the mother is at risk of death or poses a serious risk of substantial impairment of a major bodily function unless this abortion is performed or induced. Texas Attorney General Ken Paxton, who was defending the ban, praised Friday's ruling in a statement. Today, the Supreme Court of Texas unanimously upheld the Human Life Protection Act, one of our state's pro-life laws. I will continue to defend the laws enacted by the legislature and uphold the values of the people of Texas by doing everything in my power to protect mothers and babies. The Center for Reproductive Rights, which filed the case on behalf of the women last year, said the ruling did not provide meaningful clarity for doctors. Nancy Northrup, the center's president and CEO, said in a news conference that the group will continue to pursue every available legal avenue to address the suffering that is happening in Texas. Imagine the trauma of being forced to give birth to a baby who would only live hours. This is happening every day to women in Texas, Northrup said. Today's decision means the state of Texas thinks this is perfectly okay. The Texas justices took issue with the trial court's order allowing for abortion to be performed if a doctor had a good faith reason to believe the procedure was necessary. The High Court ruled doctors must hew to the reasonable medical judgment standard in the law, which the ruling described as requiring doctors to identify a life threatening physical condition that places the mother at risk of death or serious physical impairment of a major bodily function unless an abortion is performed. The state Supreme Court said a fetal condition making a pregnancy unviable was not by itself a reason that it could be performed. So if the baby is not even going to grow into a full baby, if the fetus is not going to be viable, that is not a good reason to have one. No, a woman must carry this fetus that doesn't have a full cranium or that is missing limbs or whatever, because this is good, healthy pro-lifeness. As painful as such circumstances are, that the law does not authorize abortions for diagnosed fetal conditions absent a life-threatening complication to the mother does not render it unconstitutional. Read the opinion written by Justice Jane Bland. Amanda Zarowski, a plaintiff in the case who nearly died after being denied abortion, criticized the ruling Friday, saying it feels like a gut punch. So this is Amanda's story. Her and her husband tried for years to get pregnant. They used fertility treatments to get pregnant, and they announced that they were finally pregnant. But her water broke prematurely. She says, "We found out that we were going to lose our baby. My cervix was dilating fully 22 weeks prematurely, and I was inevitably going to miscarry. She and Josh begged the doctor to see if there was any way to save the baby. I just kept asking, isn't there anything we can do? The answer was no. When a woman's water breaks, she's at high risk for a life-threatening infection. While Amanda and Josh's baby, they named her Willow, was sure to die. She still had a heartbeat, and so doctors said that under Texas law, they were unable to terminate the pregnancy. So they already know that this isn't a viable pregnancy, but they're going to wait until this woman gets septic or gets an infection that is life-threatening, like she has to be on the precipice of dying in Texas. Unfortunately, the Texas Supreme Court has showed us today that they don't wish to help pregnant women access health care, and they don't want to help doctors practice medicine in the state of Texas. The Supreme Court had the opportunity to provide clarity, but they didn't, and we're right back where we started. Anti-abortion activists, meanwhile, praised the opinion and said the ban was clear in allowing exemptions for medical emergency. The abortion lobby has created confusion on this fact to give Democrats cover for their extremely unpopular all trimester abortion agenda. Marjorie Denon Flesser, president of the anti-abortion group, Susan B. Anthony, Pro-Life America, said in a statement after the ruling, how state bans apply in medical emergencies has been a flashpoint in the fallout from the U.S. Supreme Court's decision that ended the federal right to abortion. The High Court is now considering a Biden administration lawsuit challenging Ohio's ban, which exempts abortion when a woman's life is threatened, but not when she's facing risk of bodily impairment that falls short of being potentially fatal. In Texas, the state Supreme Court previously weighed in on the medical emergency exemption with the 2023 ruling that blocked a doctor from performing one for a Texas woman whose pregnancy complications were putting her health and future fertility at risk. That was the Kate Cox situation where she had to go out of the state. The woman traveled out of state to receive the procedure. The ruling called on on the Texas Medical Board to issue more guidance to clear up confusion around when exemptions apply. The state board has proposed such guidance. However, critics say its draft rules have not clarified the question. The Texas Medical Board can and should issue guidance that translates the way the Texas Supreme Court has today interpreted the exception to the Texas bans and gives guidance to physicians about how to apply those laws in specific medical circumstances, said Mark Huron, senior counsel at the Center for Reproductive Rights. In forced birther states, even women who want to have children, even women who are having children within the sanctity of their pure Christian marriages will be harmed. They're going to be harmed like many of these women were harmed. And if these women are harmed, if they die, if they have to have surgery because now they can't have babies at all, it's still not going to help protect life or bring forth more life in these states. And all they're doing is running out physicians. They're going to make sure that women and girls don't choose their state for school or jobs. It's going to make sure that companies don't want to relocate or build new businesses in their state. And the state of Texas will deserve it because they are harming women. Okay, you guys jump in the comments. Let me know what you think about this. Don't forget to like, comment, and share.